Thanks for joining us for part 2 of representing claimants at Social Security Disability Benefits Appeals. Today, we turn our focus to an overview of the Appeals Council and the Federal District Court, as well as the appeal process for continuing disability reviews. Today, our focus will begin with Alana Avital. She is a staff attorney in our Public Benefits Unit, and Alana represents clients in a wide range of public benefits public benefits matters, including supplemental security income, Social Security disability insurance, our topics today, temporary assistance for needy families, also known as TANF, supplemental nutrition assistance program, known as SNAP, Medicaid, Medicare, and unemployment insurance. She covers a lot. Alana is also one of our pro bono mentors. So when you accept a case from Legal Aid DC, you just might have her as your mentor. 2 quick reminders. Please throw your questions in the chat box. We're going to be monitoring that in real time. And we'll take about a 5-minute break, about an hour into this today. We'll cover all of the materials, and if you all have questions at the end about our referral process, we can discuss that too. All right, Alana, all yours.
Good morning, everyone. Thank you so much for attending day 2 of the training. We are so grateful to all of you for considering taking cases at the AC level and to federal district court. Let's just dive right in. The first thing that we'll cover is AC review, how to request AC review and the standards for obtaining a granting of Appeals Council review or a success of the Appeals Council. So the deadline to request AC review of an ALJ decision is 60 days from the date on the decision. It's essentially an appeal of the decision. It can be submitted by a representative on the claimant's behalf to the AC online through Social Security's website, by fax, or by mail. The options are listed here from the most to the least reliable methods. So we highly recommend using Social Security's website, using what's called iAppeal to request review, or faxing directly to CPAB, which is slightly less reliable, but is something that can be more easily proved, and the Appeals Council can track it more easily. We recommend confirming that your request for AC review was received by calling the AC's Congressional Public Affairs branch, which we found to be extremely helpful in providing information about the status of the request. In order to get any information, however, about the status of the request or anything going on with the file, you're going to need to have a 1696 or appointment of representative form on file, which was something that we discussed on Tuesday. But we're happy to answer questions about that if anyone has them. As you can see, the AC can take quite a while to reach a decision. We've seen decisions take anywhere between 3 and 18 months. So be patient. Next slide, please. Thank you. The request for review should let the AC know the name of the claimant for whom you're requesting review, their Social Security number, and the date of the ALJ decision being appealed. So it needs to include as much information as possible to identify what exactly is being appealed here. It's an opportunity for you to request access to the record as it stood at the time the ALJ reached their decision. So this would be the hearing recording, all the exhibits, as well as the case documents that were in the file at the time the ALJ reached their decision. And the case documents are the unexhibited files. So whatever the ALJ did not move into the record. The request for an extension of time of 25 days and the request for review is also the way in which you would make sure that the AC doesn't go ahead and reach a determination without first giving you an opportunity to submit written legal argument or any additional evidence that you may not have been able to submit, or the claimant was not able to submit to the hearing office at the time the ALJ made their decision. Bear in mind that the AC will grant a request for an extension of time to whoever has a 1696 on file. So what you'll want to do is submit, if you were not the representative at the hearing level, you'll want to submit your 1696 along with your request for an extension of time to make sure that you're the representative granted that 25-day extension and receive any and all notices from the AC. If you are not able to obtain a 1696 in time by the deadline for the request for AC review, you can always submit the 1696 later. And you should also submit a letter requesting that another 25-day extension be granted to you as the newly appointed representative. Once a request for review is filed and the case has been assigned to an analyst, the AC will mail a letter granting the representative on file 25 days to send the AC legal argument or additional evidence. The deadline to submit the additional legal argument or evidence is 25 days from the date on the letter, but it's assumed it takes 5 days for the letter to reach the representative by mail. So the firm deadline would be exactly 30 days from the date on the letter. If you can't make the deadline, you can request an additional extension of time, but good cause must be found by the AC for this to happen. If the claimant missed the 60-day deadline for requesting AC review, my apologies, slide 39, Nina, thank you. If the claimant missed the 60-day deadline for requesting AC review, the AC will accept a late filed appeal as long as they're a finding of good cause. So in our experience, the most common reasons that have met the good cause requirement are the first and last reasons here. It can be particularly compelling to be able to argue that the claimant's own impairments, such as an intellectual or psychiatric impairment, kept them from being able to request review timely. Circumstances that prevent a claimant from making a request for review on time can include that the claimant or a member of the claimant's family had a serious illness, or that the claimant never received the unfavorable ALJ decision. Next, please. The bases for requesting review are, or the granting of a request for review, are abuse of discretion, error of law, a lack of substantial evidence to support the decision, new and material evidence, and a broad or policy or procedural issue could impact the public interest. In terms of abuse of discretion, the AC is to grant review where there is bad behavior on the part of the ALJ. So this would include discrimination, any indication of bias, or failure to give the claimant the right to a fair and complete hearing, which would suggest that the ultimate hearing decision reached is tainted. The most powerful argument to make before the AC, as well as before the federal district court level, is the argument that the ALJ committed an error of law. This type of error at both the AC level and the federal district court level is the most likely to lead to a remand. So be on the lookout for these types of errors as much as you can. Incorrect application of the regulations, the SSRs, the acquiescence rulings. I have included a site here so that you can look up what an acquiescence ruling exactly is. I'm not going to go into great detail here. Those types of errors are clear errors of law, as are due process violations that are the result of an error in following HALEX or POMS. A violation of the HALEX or POMS in and of itself, without a due process error, is not considered an error of law. We've seen remands due to a variety of reasons, the most common of which are listed as examples here, like improperly evaluating opinion evidence from either a treating source or from even a state agency, medical or psychological consultant. I know those opinions can easily dismissed because they can sometimes be unhelpful to our clients, or usually are unhelpful to our clients overall. However, there are elements sometimes of those opinions that perhaps were not adopted in the RFC, even though the ALJ most likely found those opinions persuasive. So you want to be looking very, very closely at those opinions and making sure that every key element of that opinion is incorporated into the RFC, particularly if the ALJ found that opinion persuasive. Another type of error that is commonly cause for remand is not assessing the past relevant work correctly, or misapplying the grids, or adopting jobs cited by the VE that don't comport with the Dictionary of Occupational Titles job description, and not proffering evidence to the claimant. The failure to proffer evidence to the claimant is more of a technical reason for a remand, but the AC is particularly sensitive on this point. It is a due process issue. And if you see anything in the file that is in the exhibit files that the ALJ would have used to reach their decision, but say made it into the file late in the game and the rep did not receive a letter proffering the evidence to them, giving them an opportunity to object to the evidence or respond to it anyway, this is a way to get a remand. So we recommend keeping an eye out for that. In terms of lack of substantial evidence, this would be another ground.
It enables you to attack the ALJ decision on the basis that it's unsupported by substantial evidence. As you can see, the substantial evidence standard is quite low. However, there is a way to get a remand based on lack of substantial evidence, and certainly a federal court will go into more detail on that later. It's that any decision that ignores evidence that would tend to contradict the ALJ's ultimate conclusions, or that's reached without the ALJ taking steps to make sure that key evidence is in the record, is unsupported by substantial evidence. In order for the AC to grant review based on newly submitted evidence, the evidence must relate to the period through the date of the unfavorable ALJ decision, and the evidence must be deemed likely to have changed the ALJ's decision had it been in the record at the time the decision was reached. In addition, there must be a good cause reason for the claimant not sending the evidence timely to the hearing office. So again, we reviewed the grounds for good cause or good cause finding above. So you would invoke those same reasons when you're trying to explain why the claimant or the representative at the hearing level did not submit the evidence timely. And the deadline for submitting the evidence would be either 5 business days prior to the actual hearing, or whatever deadline is set by the ALJ if the record was held open post-hearing for the representative to submit evidence. The basis for granting review can be, this basis for granting review can be very, very valuable to those claimants who were unrepresented at their hearing and were not able to get key evidence on their own. So you can, that's something that you can incorporate into your request for a finding of good cause. It can be a little trickier if there was a rep on file, but you want to see if you can use some of the other reasons. If the criteria for granting review based on new and material evidence are not met, there's some comfort in knowing that once the AC denial is issued, the protective filing date for a Title II claim filed within 6 months of the AC denial, or a new Title 16 claim filed within 60 days of the AC denial, will be the date of the request for AC review. So it can go back a bit, and that's very, very helpful in knowing that. And the denial, the AC denial, after you've tried to get this newly submitted evidence admitted to the AC or get the AC to review it or grant review based upon its submission, the denial that the AC issues will state this, and it will give this deadline. The most common favorable outcome at the AC stage is a remand order for a new hearing. And this remand order should, or usually will, contain rationales to what was insufficient or deficient about the ALJ decision that was appealed. The AC will also issue decisions fully dispensing with the case, including fully favor on its own, including fully favorable ones. So sometimes it takes that up. About 85% of appeals at the AC level lead to denials. Denials typically contain little to no rationale whatsoever as to why the AC denied review, which can make them extremely frustrating. Once the AC denies review, the ALJ decision becomes the final decision of the Commissioner of the Social Security Administration and appealable in federal district court. All right, so there are several reasons to take your appeal of the unfavorable ALJ decision further by not taking this hit and accepting the AC denial and filing the appeal and an appeal in federal district court. So the most compelling reason, as we've said, is that it's highly, highly likely that the appeal at the AC level, no matter how supported by great arguments, will be denied review by the AC. But do not be discouraged and do not give up. The likelihood of success increases greatly in federal court. The other is that ALJ decisions can often be sloppy and simply plain wrong. Success in federal court holds ALJs accountable. The deadline to file an appeal in federal district court is 65 days from the date on the notice of the AC notice denying AC review. So once the AC denies review, a new claim for benefits can be filed with eligibility reviewed from the date of the AC denial, with an exception for denials that deny admission of additional evidence, as we talked about in the prior slide. Even though the claimant can file a new claim, administrative res judicata would apply in a situation in which there's a SSDI application, or SSDI only application, or SSDI application, and the claimant's date last insured is in the past. We encourage clients to reapply for benefits while their federal district court claim appeal is pending for two reasons. One is to try to get critical benefits going as quickly as possible, and because the approval of the client's new claim can help their appeal in federal court, as detailed here. Next slide, please. Thank you. To file an appeal in DC District Court, if you're not barred in DC Court, you'll need to register as a pro bono attorney so that you can electronically file papers through ECF. If you're not, again, if you would file a complaint stating the basis for the appeal, such as whether there are errors of law or the decision's unsupported by substantial evidence, we're glad to provide samples if needed. So please reach out to us and let us know. You'd also need to file a notice of appearance, and there's a separate notice of appearance for those who are not barred in DC District Court. Again, glad to provide samples of this type of notice of appearance. You'll need to file a certification pursuant to Local Rule 83.2, stating that your bar membership is in good standing wherever you're barred. You're representing the plaintiff without compensation. You're appearing alongside an attorney who is barred in DC District Court, and that you have familiarity with the local rules. Again, glad to provide samples. Please do reach out to us. You'll also need to file a civil cover sheet, which is a standard form available through this link. Please reach out to us if you have any questions about how to complete the civil cover sheet, which is a little technical and can definitely be confusing if filling it out for the first time. Slide 49, please. Thank you. Lastly, you'll need an application to proceed in forma pauperis if you're seeking to waive the filing fee. So this would need to be prepared with the client beforehand. It's an attestation of the client's limited means. It details their income, their resources, the number of dependents, and any debts or financial obligations. And it does require their signature. So this would usually be the first thing that you would prepare in gearing up to file in federal district court, because it does require arranging a time to complete the form together with the client and getting their signature.
So we do recommend, after we're getting an AC denial, kind of moving on this sooner rather than later. The applicant must be of limited means. If the application to proceed in form of papyrus is granted, then the U.S. Marshal serves copies of the summonses and complaint on Social Security's Office of General Counsel, the U.S. Attorney General, and the U.S. Attorney's Office of DC on plaintiff's behalf. If the application is denied, or you're not filing an IFP, or you're not filing an IFP, which means that you would be responsible for serving the summonses and complaint, the plaintiff is responsible. You're responsible. So service must happen 120 days from the filing of the appeal. So Social Security must file its answer together with a copy of the administrative record within 60 days of service of process. And the administrative record must include a hearing transcript. It's highly recommended that you carefully review the administrative record as soon as it comes in to give you time to request that it be amended if anything is missing. So of course, knowing whether anything is missing would involve having access to the exhibit files as they stood when the ALJ reached their decision. So we suggest downloading the exhibits and hearing audio from ERE immediately after receiving the ALJ decision. Or if you don't represent the plaintiff at their hearing, if you didn't represent the plaintiff at the hearing, then we suggest that you obtain it from the person who is the appointed representative from the hearing stage so that you can compare the files and make sure everything is there. So this would include listening to the hearing audio and making sure that what is in the hearing transcript accurately reflects what actually happened at the hearing as well. If the administrative record is inaccurate or if it's missing anything, Social Security should agree to amend the administrative record. But if not, and you run into problems there, you can move to supplement the record. So the Federal Rules of Civil Procedure were amended on December 1st, 2022, very recently, to include supplemental rules for Social Security actions, which now require plaintiff's initial brief to be filed within 30 days of the filing of the government's answer, and that Social Security's response be filed within 30 days after plaintiff's motion is filed. Prior to December 1st, 2022, the parties negotiated a briefing schedule, typically giving the plaintiff 75 days to file their brief or their motion for judgment of reversal, and 45 days for Social Security to respond. Now the court issues a scheduling order immediately after the answer is filed with the timeline laid out in the supplemental rules. However, the deadlines can be modified by motion and the scheduling order will state so. So don't despair. All right, there are two types of district court remands, sentence 4 and sentence 6. A sentence 6 remand involves a final appealable judgment affirming, modifying, or reversing the commissioner's decision, and often, but does not have to, but will most likely contain an order to remand the case for a new hearing. A sentence 4 remand sends the claim back to the hearing office to deal with the new and material evidence that could change the decision's outcome. The district court continues to have jurisdiction over the case while the rehearing dealing with the new evidence plays out. Social Security must return to the district court with a new hearing decision and a transcript of the supplemental record that the new hearing decision is based on. All right, a sentence 4 remand can be the result of an agreement between Social Security's attorney and you, the attorney for the plaintiff, to remand the case for a new hearing. There can also be an agreement to reverse the decision and grant plaintiff's claim, but this is highly, highly unusual. If Social Security opposes plaintiff's motion for judgment of reversal, the court decides the case with outcomes consisting of affirming the commissioner's determination and denying plaintiff's motion for judgment of reversal, granting the motion with a remand for a new hearing, or granting the motion, reversing the determination completely, and ordering that benefits begin immediately. And this is an amazing outcome, and I hope that all of you have the opportunity to achieve it. As long as the ALJ's findings of fact are supported by substantial evidence, right now we're on slide 54, are supported by substantial evidence, the district court will defer to them. However, the substantial evidence standard does not give findings of fact a free pass. In order to be supported by substantial evidence, the decision must address all of the probative evidence. It must explain the weight the ALJ gave to that evidence and how the ALJ's assessment of the evidence factored into the decision. Whether the ALJ actually did this is entitled to careful scrutiny, which I personally think is pretty powerful language. So the ALJ's failure to address contrary evidence or to meaningfully engage with the evidence and explain why, despite its existence, the claimant still does not meet the definition of disability should lead to a finding that the decision is unsupported by substantial evidence. Errors of law are entitled to less deference than findings of fact. And for this reason, we recommend arguing to the greatest extent possible that the ALJ committed an error of law. Slide 55. Okay, so the harmless error doctrine is a very important doctrine and one which an attorney looking at whether a denial from the EC should be appealed in federal court should bear in mind. The doctrine is that even if an ALJ made an error or misapplied the law in reaching a decision to deny the claimant, that error cannot lead to a finding that the claimant is entitled to a reversal or a new hearing if the unfavorable decision would still have been reached had the ALJ not committed the error. It's the plaintiff's burden to show that the ALJ's legal error was harmful, or to put it in other words that really do capture how the court will approach the issue, it's the plaintiff's burden to show that the error was not harmless to the plaintiff. So the not harmless argument should be prominently argued in the plaintiff's motion for judgment of reversal to anticipate Commissioner's response that the error was of no real consequence because the balance of the evidence supports the ALJ's ultimate determination. Harmless error would occur, for example, in a situation which, say, the ALJ did not evaluate whether a claimant that had peripheral neuropathy met the relevant listing for peripheral neuropathy, which is 11.14. But the evidence still doesn't show that the claimant's peripheral neuropathy actually met the listing. So making that argument it doesn't illustrate that it's a harmless error, essentially, because ultimately the evidence doesn't support that individual meets the listing. So the error is of no consequence, really. And there are other examples of harmless error, and I encourage you to take a look at Glass versus Saul, which is the case cited here, which addresses, whether the ALJ conducted the right analysis and looking at whether an individual with moderate limitations in concentration, persistence, and pace could perform simple routine work as defined in the RFC adopted in the decision. And so ultimately that error, even though the ALJ was required, should have really engaged in some additional analysis, was ultimately found to be harmless because the balance of the evidence supported the determination that the individual could perform simple routine work basically without more. Slide 56. So some key case law to keep in mind here. You can raise arguments before the district court that were not argued before the ALJ or the appeals council or before the appeals council. The commissioner can't try to rationalize the decision after the fact. The required rationale must be contained in the decision itself. And again, as we discussed earlier, the decision must contend with probative evidence. Slide 57. These are just some examples of harmful errors at different steps of the sequential evaluation that have led to remands. These cases are also particularly instructive on how the ALJ's approach to the sequential evaluation is looked at in district court. Slide 58. Again, more examples here. The requirement that there be an adequate logical bridge between the evidence and the ALJ's formulation of the claimant's residual functional capacity is an extremely important one, and helpful in trying to bolster what might otherwise be solely a substantial evidence argument. So it's a good case to cite. Slide 59. What if the commissioner agrees to a remand? Your arguments are just so fantastic and they agree, and they think that this claimant should get a new hearing. So a stipulation to remand the case would be negotiated between the attorneys, between the parties, in which case it's a good idea to try and capitalize on this and try to get the stipulation to have terms that would make a favorable decision after the new remanded hearing more likely. So for example, if you think that ALJ was particularly problematic, you could try to get the case assigned to a different ALJ. You could try to negotiate requiring the ALJ to order a psychological evaluation, literacy testing, or testing of the claimant's intellectual abilities before reaching a decision. Slide 60. Thank you. If the case is successful, either by way of an agreement to remand the case or by way of a decision, you can collect fees from the government under the Equal Access to Justice Act. You'd first try to reach an agreement with opposing counsel as to the amount of fees to be paid. The court has defined 20 to 40 hours as reasonable. A reasonable amount of time spent working on a case with non-complex legal or factual issues. There must be sufficient detail as to what tasks were performed in working on the case. Slide 61. So sufficient detail or sufficient timekeeping has been found to exist where the attorney further defined what section of the motion for judgment of reversal or the reply brief was being drafted, or what legal issue was being researched in working on the case. Equal Access to Justice Act fees are capped at $125 per hour, but with a cost of living adjustment contained in the National Urban Consumer Price Index. Slide 62. If you can't reach an agreement with opposing counsel on the Equal Access to Justice Act fees, you'll need to file a petition for fees. The fee petition must be filed within 30 days of the court decision becoming final and non-appealable. And again, Legal Aid is very happy to provide samples of these types of petitions. Slide 63. Plaintiff's burden in filing the Equal Access to Justice Act petition for fees is merely that the plaintiff prevailed and incurred the fees. However, again, the description of the work performed must be sufficiently detailed and request fees for a reasonable number of hours. And the court has expounded on this quite clearly. The defendant will be ordered to pay reasonable attorney's fees unless they successfully make the argument that the government's position was substantially justified. And this is defined as a position that is justified to a degree that could satisfy a reasonable person. This standard has been interpreted in a case called Harvey v. Berryhill, and I recommend reading that case. I think it's a very helpful case in trying to understand this substantially justified standard. Slide 64. All right, so that concludes our presentation on requesting AC review and federal district court review of an unfavorable ALJ decision. We do appreciate so much you considering taking these cases, because these benefits are so incredibly critical to our clients and their families. And such a profound difference can be made when we prevail in these cases at these levels. Because we recognize that these cases do take some effort, we're here if you have any questions or and to provide mentoring with significant guidance along the way. Mentorship includes discussing potential arguments, brainstorming, providing templates and samples, and reviewing and editing any drafts that you would like to share with us. We hope you consider this when you decide to accept a case at the AC and federal district court phases that's been referred by us. And we're going to take a 5-minute break. And when we come back from the break, the training will turn over to Sacha, who will go over continuing disability reviews. Thank you so much.
Hi, everyone. My name is Sacha Robinson. I am a staff attorney here at Legal Aid in the Public Benefits Unit. And if you were able to attend on Tuesday, I did part of the presentation on Tuesday, and I am thrilled to be here again talking about disability benefits. So far, this training has been focused on how does someone start receiving Social Security disability benefits? How do they go about the process of proving that they meet that disability standard to start getting benefits? I want to switch gears a little bit and talk about continuing disability reviews, which this is a process that only applies to people who have already been found disabled and are already receiving Social Security disability benefits. So that means that CDRs apply to folks who either were approved when they initially applied or won their appeal at the various stages of appeal that we've talked about between Tuesday and today's presentation. The basic premise of continuing disability reviews is that someone, once you're found disabled and you're approved initially, you must continue to meet certain requirements showing disability. Social Security conducts regular evaluations of people who are receiving disability benefits, and these evaluations are called continuing disability reviews, or CDRs. And these CDRs just make sure that people continue to meet disability requirements. Okay, so continuing disability reviews typically occur about every 3 years. There can be some variation on when these happen, but for, generally speaking, someone can expect to go through the CDR process every 3 years. And during the continuing disability review process, Social Security does not review the disability decision de novo. So this is not going through that sequential evaluation that Nina discussed on Tuesday again. So it's not that same test that's used. Instead, Social Security uses a medical improvement standard. So this is a new evaluation process that is used, and that's what we're going to be covering for the second half of the presentation. The continuing disability review standard precludes and stops judges or other Social Security representatives from second guessing the original disability decision. Social Security is determining whether the health condition of an individual receiving disability benefits has medically improved to the point that they are now able to work. I think it's worth noting here that the medical improvement that Social Security is looking at must be in the ability to do work-related activities. So someone just simply having some medical improvement over a period of years is usually not enough. And I'll go through that in more detail in a few slides. So Social Security law loves multi-step processes. And so I am going to go through another multi-step evaluation process that is different from the one that we went over on Tuesday. There are some similarities, though, which I will do my best to point out the similarities and differences from the initial eligibility, 5-step sequential evaluation process. So for continuing disability reviews, there is an 8-step process. And so I couldn't fit all 8 steps on one slide, so we'll be going through it. It will take a few slides to cover the entire process. And I also have a flow chart for folks who appreciate visualizing the steps rather than having it in a word basis. So the first step, this should be a familiar step. Social Security looks at, is the claimant performing substantial gainful activity, SGA? And so, this is a concept that should be familiar from last session. Social Security is looking at whether they have earnings of gross income per month of more than $1,470. And that number changes each year. So in 2023, that's the amount that Social Security is looking for. If someone is receiving disability benefits and is earning more than $1,470 a month, then Social Security will find that their disability has ended. If someone is working but earning less than $1,470 a month or is not working at all, then Social Security will continue to the next step in the process. So the second step is, does the claimant have a condition included in Social Security's listings of impairments? That should sound familiar. And the listings of impairments are a list of medical conditions that Social Security has designated as being so severe as to prevent a person from doing any gainful employment. Again, this should sound familiar from last session, and we will do a quick refresher about the listings of impairments. If Social Security finds that the individual does meet a listing, then that ends the process. Social Security will find that their disability continues. If they find that the individual does not meet a listing, that does not necessarily stop their disability benefits. It just means that you need to go to the next step. The next step, step 3, has there been medical improvement? Like I said, this is the hallmark of the continuing disability review process, is medical improvement. So we'll go into some detail about what medical improvement means and what are the things that are being considered at this step. If there has been medical improvement, then Social Security will look at the next step, which is the medical improvement related to the person's ability to do work? And if so, then they'll go to the next step. So I'll go on to the next slide. So there are some exceptions to the medical improvement standard. I will talk about them in a few slides, but if there's been no medical improvement or medical improvement is not related to ability to do work, then someone's disability will continue. If no, right? So if the exceptions apply, one of the exceptions apply, then that means that your disability ends or you go on to the next step in this process. So the next step is, are the impairments severe? So this is a fairly de minimis test. It relates to step 2 of the original sequential evaluation that was discussed last training session. And it's a pretty low threshold for Social Security to find that an impairment is severe. The next step is determining what the claimant's residual functional capacity, or RFC, is, and whether that person can perform their past relevant work. If they're able to perform their past relevant work, then disability is found to have ended. If they cannot perform their past relevant work, then you go on to the last and final step, which is whether the person can perform any full-time work in the national economy. And this is an analysis that looks into the individual's education, age, and prior work experience, and is looking at their residual functional capacity. So if the answer to that question is no, that they can't perform their past work and there's no other work that they can adjust to in the national economy, then the person's disability is continued. If there's other work that they could perform, then the disability is found to have ended. So through this process, there are 3 different paths to finding that someone's disability has continued. And this is just a flowchart visualization of the different steps that I just went through. And you can find, I couldn't fit it all onto one slide, but you can find this chart at the website that's listed in this slide. Okay, so now I want to walk through each of the steps that I just described. So the first step was substantial gainful activity, which is a fairly easy step to figure out, is someone working and earning above a certain amount. The next step is, does the individual meet a listing? Which again, this should be familiar because we discussed it last session, but Social Security has a list of impairments. You can find them easily online, where they will kind of list out a variety of health conditions and what symptoms need to appear in the individual's medical records, and the symptoms that they experience in order to qualify that they meet that listing and are found disabled. So I have here again an example of a listing. This is for systemic lupus erythematosus, and it just goes through and shows what an individual must show that they have in order to find that they meet that listing for lupus. So this is just a refresher from Tuesday. Okay, the next step is a departure from what you have heard before. This is medical improvement, which again is the hallmark of the continuing disability review process. To determine whether medical improvement has occurred, there must be a comparison. This step requires comparison between 2 periods of time. So what Social Security is looking at here is, has there been a decrease in the medical severity of the impairments which were present at the time of the most recent favorable medical decision that someone was disabled or that they continued to be disabled. Medical improvement is a finding that there has been that decrease in medical severity, and it must be based on improvements in symptoms, signs, or laboratory findings associated with the impairment. So again, I said this requires comparison. So what Social Security is doing is that they're looking at the comparison point decision, or CPD, and they're comparing it to the current medical severity. I will discuss on the next slide more about the comparison point decision, but you're looking at the most recent favorable medical decision that Social Security has made. Okay, so more about the comparison point decision. This is a really, really important part of the medical improvement standard. The comparison point decision is the most recent favorable medical decision that Social Security has on file. There are a few components of the comparison point decision, and it's important to make sure that you as a representative are able to see all of these components in the comparison point decision. So the comparison point decision must include the prior decision, the actual decision that found them to be disabled most recently. It must include a complete documentation of the sequential evaluation process that was used in the adjudication. So the decision plus walking through that sequential evaluation process that was used. And then last, and which is commonly missing, is all of the medical evidence that was looked at and used when that prior decision was made. It's not enough to just have the decision that found your client disabled, let's say 3 years ago. You must also be able to see all the medical evidence that that adjudicator looked at when they found this person disabled the last time. And I think that third bullet is really important and is commonly the one that's missing from the file. And I'll talk a little bit about some practice tips with comparison point decisions. I first want to just say, why is the comparison point so important, right? One, medical improvement requires comparison between one point in time and the current time. But also, if the comparison point decision cannot be found, then someone's disability must continue. Social Security must continue their disability, or they have to go through a very complex process of seeing if they can reconstruct the missing file. So the comparison point decision is a really important part of this process. When you are looking through the Social Security files to figure out if you can find the CPD, it might be in the Electronic Records Express, the electronic database that Social Security has housing all of the files related to this individual's claim. It might be in the F section, which is where they house medical records. It might be labeled something like prior folder medical evidence. It might just say CPD. It's possible that it is in the record, but it doesn't have an exhibit number. So there's another place that you can look that I believe says case documents or I think it's case documents, but there are several different places you can look in ERE to try and find the information. However, as you're looking through it, you might notice it's not there. And that might be because it is not there. And so it is often missing. And so what it's really important to do is to request that the CPD, the comparison point decision evidence, be added to the case file and exhibited. So you can send a letter to Social Security. You can just upload it into ERE because Social Security has the obligation to find and include all of the CPD evidence. Again, if they cannot find it, then that means that disability must continue or they have to reconstruct the lost file. So this is really important. Okay, so just to rehash, medical improvement is not a relitigation of the initial decision. Even if Social Security rules have changed or the adjudicator that's looking at the case now disagrees with the initial award, there must be a finding of improvement to end these benefits at this step. And so I wanted to give an example of medical improvement so that you can kind of see it in action. So you were awarded disability benefits due to a herniated disc. At the comparison point decision, you had a surgical procedure on your spine. The postoperative notes show persistent deficit in your lumbar spine. You had pain in your back and pain and a burning sensation in your right foot and leg. No muscle weakness or neurological changes occurred, and you've had a modest decrease in the range of motion in your back and leg. During the continuing disability review process, medical records show regular doctor visits since the comparison point decision. There have been no further procedures or scans, but there are continued complaints of pain in the back and right leg, especially sitting or standing for more than a short time. Your doctor reports moderate decreased range of motion, but no muscle weakness or neurological changes. So here, there has been no medical improvement. There should be no medical improvement found because there was no decrease in the severity as shown by there were no changes in symptoms, signs, or lab findings. So this is a case where Social Security should find that no medical improvement has occurred. And if you're going through this process, your disability should be found to continue. So if you're in a situation where your client has experienced medical improvement, the next thing that the adjudicator will look at is whether that medical improvement, those changes in the individual's functional capacity have to do with basic work activities. So the medical improvement must be related to the ability to do work. So I have an example here that hopefully will help you understand the nuances of this step of the process by putting it to work. So for example, at the comparison point decision, you have a claim. This is a claimant with circulation issues. They have some issues with their veins. So at the comparison point decision, the claimant had venous insufficiency and persistent swelling. The claimant was able to sit for 6 hours, but was able to stand or walk only occasionally. At the time of the continuing disability review, the claimant had undergone a surgery. They have lost 25 pounds and now they have intermittent swelling. So it's decreased from persistent swelling to intermittent swelling. They still are able to sit for 6 hours and stand or walk occasionally, although they have less discomfort when walking. This is a situation where there has been medical improvement, but that medical improvement is not related to the ability to do work because their functional capacity to do basic work activities has not changed. So I think some of the key things here are that their ability to sit, stand, or walk has stayed the same throughout this process, even though they have had some medical improvement. Okay, so I mentioned that there are a handful of exceptions to the medical improvement standard, and as you're kind of walking through the steps in the flow chart, this is one of the steps. So looking at the exceptions. And so if none of the exceptions apply, then Social Security will find that your disability continues. However, if you're at this step in the process, which you don't always make it to this step just based on the way the process flows, but if you're at this step, then Social Security will look at if some of these exceptions apply, then that means you continue in the process and go to step 6. Whereas if other of the exceptions apply, then that means that your disability has ended. So here, if there have been advances in medical or vocational therapy or technology since the comparison point decision, if there are new vocational therapy techniques, if there are new or improved diagnostic techniques, or if there was a prior error, then in those situations, these exceptions would dictate that the Social Security adjudicator will go to another step in the process. So they'll go to step 6. If, however, the exceptions of fraud in the initial decision, failure or refusal to cooperate, or failure to follow a prescribed treatment apply, then Social Security can find that the disability has ended. Okay, so now I've talked about some of the steps in the process that are significantly different from the initial eligibility sequential evaluation steps that we talked about in the last training session. The next steps in the CDR process, steps 6, 7, and 8, all resemble that initial eligibility sequential evaluation process, right? So are the impairments severe? That's an analog to step 2 in what was discussed last session. The next step, what is the claimant's residual functional capacity and can they perform past relevant work? And last, can they perform any full-time job in the national economy given their education, age, and prior work experience? So again, I think that repetition can help process and help folks learn these really complicated, laws and requirements around disability law. So I'm just going to give a quick refresher of what was covered last session. So, at this step in the process, Social Security is determining what someone's residual functional capacity is. And so that means they're looking at what's the maximum ability to do sustained work. And that's the ability to do sustained work-related physical and mental activities in a work setting. So they're going to look at, generally 8 hours a day, 5 days a week. And they're looking at what you can do despite your limitations. And Social Security needs to look at all of the individual's impairments and the total limiting effect of those impairments, even ones that are non-severe. So they will take that residual functional capacity and they will compare it to past relevant work that has been performed at the SGA level in the past 15 years. If Social Security finds that someone can perform their past relevant work, then that means that they would say their disability is not continued. Their disability has in fact ended. They can go back, do the work that they were doing. They've improved to that point, and their disability stops. If, however, Social Security finds that this individual's residual functional capacity limits them so that they are not able to perform their past work, then we go to the next step. Is there any full-time work that they can do? So this is where we're looking at, can the individual perform any full-time job in the national economy? And so Social Security will determine their residual functional capacity, look at their age, education, work experience, and skill level. They will look at the grids, which again is kind of a chart that Social Security has that determines whether someone's disabled based on their age and what their exertional level is, whether they're able to perform sedentary or heavy work, those types of considerations. And if there are any non-exertional limitations, then the grids are not binding. Which, as a reminder, non-exertional limitations are different from, kind of the more physical components of a job and deal with mental limitations such as difficulty maintaining attention or concentration, difficulty understanding or remembering instructions, difficulty relating with others. It might relate to someone's ability to see, hear, speak, or feel, these kind of sensory limitations, whether someone has manipulative limitations that impact their ability to reach or handle, fine motor control. And so we have a list here, and this you will everyone will receive a copy of these slides, but these are the types of limitations that you're looking at that might dictate deviating from the grids. And this is the last step in the continuing disability review evaluation process. So we talked, in the initial eligibility stages, kind of what the application and appeal process looks like. The continuing disability review appeals process is different from that initial eligibility process that we discussed last session. So the first step in the continuing disability review appeals process is that when it's time for Social Security to review your case, Social Security will send an individual forms in the mail. And those forms will just ask them for updated information on your condition, who your providers are, what your medications are. It's just asking for an update on those types of things so that they can review records and kind of put together all of the information that they need in their file. Social Security will take that information back from the mailers and forms that the individual fills out, and they will make a determination. So they will mail the individual a notice informing them of the decision that was made. So Social Security will make a decision that their benefits continue, that their disability continues, or that they're finding that their disability ceased or stopped. An individual has 60 days to appeal this cessation notice. The appeal is a request for reconsideration. Again, that should be familiar phrasing for folks, where in the request for reconsideration stage here in the continuing disability review process, an individual has an informal hearing before a disability hearing officer. So this is not a hearing in front of a judge. And this is typically by phone or video, especially during the pandemic. And the individual can have a representative with them, and they can ask to see the comparison point decision in advance. The disability hearing officer will write up kind of like a report or decision, and the individual should receive a copy of that decision whenever a decision is made. And again, here, the disability hearing officer might find that their disability continues, or they might find that their disability did in fact cease, and so the denial stands. If the person is denied again at the recon stage, they have 60 days to appeal. The next stage should again feel very similar to folks who were able to listen in to this entire training. The claimant has the opportunity to request a hearing before an administrative law judge. These hearings are very similar to the initial eligibility hearings. And so I think all of the advice and tips that we gave, most of the advice and tips that we gave on Tuesday's session about how to prepare, expecting a vocational examiner and some tips about dealing with vocational examiner, all of that applies to these hearings, these continuing disability review hearings before an administrative law judge. One difference is that the 5-day rule to submit evidence, which normally in an initial eligibility case, you have to submit all evidence at least 5 business days before the hearing. That rule does not apply in the continuing disability review process. So evidence, including medical records and a brief, can be submitted at any time before the decision is issued. So they can be submitted even after the hearing has occurred, but before a decision has been issued. Of course, it's best practice to submit all of your evidence and your written arguments before the hearing so that the judge has enough time to review it, and it can perhaps help inform the questions that are asked at the hearing by the judge or the vocational expert. But there is not a requirement that it be submitted before the hearing. It can be submitted anytime before the decision is issued. If an individual is denied at the administrative law judge stage, they have 60 days to appeal. And the next steps are to go to the appeals council. And if you're denied at the appeals council, you can appeal to federal district court. So again, there are a lot of similarities to the kind of processes that we have described up to this point, but there are little differences here. One difference is that in a continuing disability review case, an individual can reapply for disability benefits at the appeals council stage. So if they're denied at a hearing and they decide to appeal to the appeals council, at that point, they can then submit a new application for disability benefits. If you're unsuccessful at the appeals council, you have 60 days to go on to federal district court. And what Alana discussed, kind of the procedures and some common arguments apply to these types of cases as well. One final point of distinction that I would like to talk about today in the continuing disability review process is the opportunity and availability of benefit continuation. And this is different from in initial eligibility stages. So when someone is already receiving disability benefits and they're going through this continuing disability review process to see if they can continue to receive benefits, they may receive their disability benefits all the way up through the ALJ hearing stage if certain conditions are met. So that means that even though Social Security has found that they're claiming that the disability has stopped, if you are appealing that process, if you meet certain conditions, you can continue to receive your monthly benefit up through the hearing stage while you're fighting the appeal. Benefit continuation can be selected if the appeal is filed within 15 days of the date on the notice. There is one exception to that 15-day rule, and this is due to some temporary changes that were made during the pandemic. But through June 21st of this year, which it could be extended, SSI recipients who request reconsideration on a continuing disability review within 65 days of the date on the notice shall receive payment continuation unless they waive it. So this kind of turns it on its heel where there's no kind of you have to appeal within 15 days. As long as you appeal within that 65-day timeline, then they will continue your benefits unless you affirmatively tell them you do not want benefits to continue. This can be a huge benefit to clients, especially SSI recipients, because these are often lifeline benefits for folks who don't have another source of income, have limited means and limited income. And, who oftentimes, with the assistance of lawyers, are able to succeed in their appeals process. So this means that they're not going an extended period of time. They might not go an extended period of time without, key crucial monthly income that you and the individual believe that they're entitled to. I have a link here that will take you to that emergency message. You can check and see if you are taking one of these cases, if that emergency message gets continued or extended. And in which case, then it will revert back to everyone, falls within that 15-day timeline, where if they appeal within that time period and request benefit continuation, then they can continue to get that. Okay, that is the end of our pre-planned presentation. I'm not sure if there have been questions in the chat, and so I will kind of turn to Nina and Ilana to see if there are any questions that we want to answer live or repeat in the chat. But I really appreciate everyone's time. Social Security law can be complex, but there's such pro bono attorneys have the ability to make such a difference in these cases because it is really complex law, and it can be hard for an individual to make these arguments on their own. So we are here to answer questions. If you do take a case, we have pro bono mentors who are very excited to answer questions that you might have about these cases to make sure that as many clients and claimants in DC are getting high quality representation in these Social Security hearings. So thank you. And with that, I will mute so that Ilana and Nina can maybe bump up some of the questions in the chat.
Yeah, so Sylvia has asked us to read out loud the questions in the chat and the answers since this presentation is being recorded. So the first question is, are appeals common or regular occurrence? And yes, they are a regular occurrence, very common. Second is, does it take 3 to 18 months just to hear if a request for AC review is granted? Answer is that the 3 to 18 month time frame is how long it can take to get a decision on your appeals counsel review. Next question is, do you have to have something new to file a new claim after denial? Answer is, you do not need to have a new diagnosis or condition to file a new claim after getting a denial from the appeals counsel. Because time continues to pass, the individual will likely have new additional medical records that Social Security will review in the new application. Next question is, are the equal access to justice fees only for work before the court, or could it be work done while the court still has jurisdiction, but the case is back before SSA because of a remand? Answer is, we believe it depends on what type of remand is ordered. In most cases, though, the equal EAG fees are only for work done at the federal district court level. And then next question is, at the continuing disability review, is it required that the client continue to seek medical care testing in order to meet the medical improvement standard? Answer is, it's not required. Because Social Security can send clients to their own medical consultants, but it typically helps since Social Security medical consultants can often have a very skewed perspective. It looks like we have one last question here that I'm not sure is viewable to everyone. So I'll read out loud, definitely good to read out loud. When Social Security evaluates the transferability of a claimant's pre-disability skills, how do they account for this when the disability was present at birth? So answer is, duration is considered. So it'd be helpful if a person had disability present since birth, even though technically speaking, Social Security may only be looking at a certain time period to evaluate disability. Next question is, if a claimant receives an unfavorable decision, they want to take their case to the appeals council, do the IDA benefits continue out? It's a good question. And our information on this has changed. I feel like sometimes the policy manual, the DC Department of Human Services policy manual has changed. And Satya, you'll have to remind me where I think we recently landed. I think we recently landed that the answer is no. They are technically not supposed to continue, even if they do continue, because DHS just doesn't notice. What are your thoughts on that?
Yeah, that's right. So interim disability assistance, which is the temporary cash assistance program for folks who are waiting for an SSI decision to be made. So IDA benefits are supposed to stop when you're denied at a hearing stage. DHS is like legally permitted to stop their benefits and probably in fact should stop their benefits. We have noticed that oftentimes DHS will continue IDA benefits, but when they do, it really is just probably like a process failure on their part. And so we often advise our clients that they cannot rely upon their IDA benefits continuing if they take a case to the appeals council, that in fact we would not be able to help them fight their IDA benefits being denied because in fact legally DHS can stop that. But oftentimes it will continue. So it's a bit of a gray answer there.
Any other questions?
And one thing I will just add to that last question is that if you are helping someone in a continuing disability review and they are denied at the appeals council, they're denied at the hearing stage, they can submit a new application while the case is pending at the appeals council. So for folks in that position, they could then apply for IDA based on the fact that they have a new application pending.
And just so you all know, the training manual that we will be circulating has more detailed information of all of these things. All right, not seeing any other questions. Sylvia, do you want to wrap things up for us here?
Sure. I want to thank you all for coming, and I want to thank our presenters. For those of you who are interested in picking up a case, I encourage you to reach out to me. We are regularly circulating opportunities each month, and happy to find something that is well suited for your level of expertise. And as we've pointed out several times throughout the presentation, we do offer mentorship in addition, excuse me, in addition to all of the resources, the training materials written and recorded. In addition to those, we also have mentors, and please be mindful that they are not co-counseling with you on the matter, so they won't attend. They won't attend hearings with you. They won't join you at your client meetings, but they are available to assist you with thinking through the matter and how to best present the case on your client's behalf. So please reach out. We are always in need of new pro bono attorneys to take on these cases. And I think we've talked about how tremendous the impact you can have will be. Otherwise, I think we are all set, and I appreciate you joining us today.